Next from Chicago, we attend a portion of a committee hearing on the fraud investigation into Governor Quinn's now-defunct Neighborhood Recovery Initiative program. We first hear from Representative Scott Drury, a former federal prosecutor, who asked that the state delay its investigation of witnesses for 90 days so that federal authorities can proceed with their investigation. After Representative Drury makes his appeal, committee members question attorneys representing witnesses involved in the case about the witnesses' plans for complying with the investigation. This runs about 1 hour and 10 minutes.
Actually, this is related to the duties of the Legislative Audit Commission, specifically, and to getting some expert testimony on an issue of whether we should move forward. Representative Drury.
Thank you, Mr. Chairman. Again, I come here today as a colleague, and I appreciate the opportunity to speak, but more importantly, I come here today as a former federal prosecutor to strongly encourage this committee to heed the request of the United States Attorney for the Central District of Illinois and refrain from conducting interviews or taking testimony from witnesses for 90 days. In making this request, I have read the 2 letters that have come from the U.S. Department of Justice and from the United States Attorney himself. Based on the recent letter from the United States Attorney, this committee or commission should be very concerned that its failure to put the brakes on witness interviews and hearings could impede or obstruct the progress of a federal criminal investigation. At a minimum, this commission should act responsibly and talk with the federal government about its concerns to find out what is in the public's best interest moving forward. It is my understanding that these meetings have not yet happened. In a worst-case scenario, the Commission's failure to respect the U.S. Attorney's request could interfere with the federal government's ability to properly investigate and, if necessary, prosecute any criminal wrongdoing that may have occurred. Beyond interfering with justice, such a result would reinforce the widely held public belief that Illinois is not serious about tackling public corruption. As you know, I've only been in the General Assembly for about 1.5 years now, so this type of legislative process is new to me. But what is not new to me is how federal criminal investigations work. Before joining the General Assembly, I was an assistant U.S. attorney here in Chicago for over 7 years, during which time I investigated and prosecuted public corruption matters, among other things. A key aspect to any serious criminal investigation is that it is not conducted in public. Indeed, by law, a federal grand jury is secret. One important benefit of non-public proceedings is that witnesses may talk more freely and honestly, knowing that their comments will not show up in the nightly news. The purpose of a grand jury investigation is to find out the truth, not get a soundbite for each day's news cycle. Sometimes the evidence reveals that there is probable cause and that the persons under investigation committed a crime, at which time charges are brought in public. We saw this process happen with Governors Ryan and Blagojevich. It worked. Other times it turns out that there is not probable cause that a crime was committed. In that case, no charges are brought and the details of the investigation are not made public. Importantly, under either scenario that I just described, this commission could still conduct its hearings at a later date if it so chooses. Presently, this commission should allow the federal criminal investigators to do their jobs. The fact that the U.S. Attorney had to acknowledge in public that a criminal investigation has taken place may have already impeded or impaired its investigation. This commission should not compound the harm by moving forward with a hearing that could just as easily take place 90 days from now. I have heard the argument that this commission owes it to the public to conduct these hearings. However, it is beyond question that the public has more trust in the federal government when it comes to matters of eradicating public corruption than any state body does. Moreover, if it turns out that these state hearings actually interfere with the federal investigation and prevent future charges from being brought, those here today pushing for the hearings will learn how counterproductive their position actually was. But by then it would be too late. The damage will have been done, and Illinois' credibility will have taken yet another hit. This conclusion is not any different even if these hearings yield good political sound bites at the end of the day. Assuming that the goal of this commission and its members is to find out what happened with the Neighborhood Recovery Initiative, partisan politics and politics generally must be put aside in favor of a search for the truth. History has shown that the federal government is best equipped to find out that truth. While I again encourage this commission to heed the request of the U.S. Attorney and stand down on witness interviews or testimony for the next 90 days, good government and public trust demand that the commission take such action. Thank you.
Thank you. I appreciate your view as a former prosecutor. At this time, I would like you to remain. We have some questions for members of the commission. Sand expert?
Oberweis.
Representative Oberweis. Oh, I know you. I just wanted to see who was next in line. Senator Oberweis.
Representative, thank you for joining us here today and providing your testimony. Just a couple of quick questions. Did you just read your testimony?
I had testimony that I read from, yes.
And did you share that testimony with others before this presentation?
I did not.
So no one else knew what you were going to say?
My wife may have had a sense of what I was going to say.
Did you discuss this testimony with any of your colleagues?
I discussed the fact that I would be here and would be willing to testify, but I did not discuss the contents or what I would be testifying about.
Could you tell us how you, obviously you didn't just decide to walk in today because you knew there was a hearing and be available. You must have discussed with someone that you would be willing to testify. With whom did you discuss that?
Well, the history of this is I've been following this proceeding very closely all summer, as it's been
As we all have.
as it's been showing up in the Tribune and the Sun-Times, and have concerns as a citizen, not just as an elected member of the General Assembly. When I saw, I believe it was last Thursday, that the Department of Justice had made the first request, I started actually writing an op-ed because I thought that it was very important that this body not move forward with these hearings. And I started working on that with my internal staff of what we were going to do. There are various drafts of that that were never completed. I believe it was sometime earlier this week that I made contact with members of the commission, and we just had a mutual discussion about what do these requests mean, and what would happen, what are the consequences of moving forward with this, and are you familiar with these types of requests? And I said I was. And so the question was posed to me, would you be willing to come and share that with the commission? And because I was already inclined to be writing on this topic, because I believe, again, passionately, that we should not be interfering with a federal investigation. And that is the normal process that I've been familiar with, that when two bodies, whether it's the State General Assembly and the U.S. Attorney's Office, the U.S. Attorney's Office, and the Attorney General, there's been some writings about a letter that my former boss, Pat Fitzgerald, wrote to Attorney General Lisa Madigan, where they agreed to work things out. I know that this happens on the state side with State's Attorney Alvarez and the U.S. Attorney's Office. They work it out, and they don't work it out in a public hearing like this with cameras all around because it's not in the best interest of the public and doing justice. So when I was asked, would you be willing to come and testify, I said, absolutely.
By whom were you asked?
By whom was I asked? I discussed this matter with Will Cousineau.
I'm sorry, with whom?
Will Cousineau.
I don't know who that is. Who is it?
He's Will Cousineau.
Is he? So he was just a friend, and he just happened to have an interest, so you started discussing with him?
I don't know. I don't know what his official position is. I know that I don't know if he's a member of the Speaker's staff, what his exact title is, where his paychecks come from, but that he's on the floor of the General Assembly every day in the House of Representatives.
You said you discussed this also with members of the commission. Which members?
The members sitting here today.
I'm sitting here today. It was not discussed with me.
The Democratic members sitting here today.
So let me understand this. You discussed this only with the Democratic members, but you said in your testimony that you just gave that politics must be put aside in the search of the truth.
Absolutely.
Does that sound like you're putting politics aside in the search of truth when you discuss your testimony with one side and not the other side of this commission?
My understanding was that attempts had been made to talk with their side, because I'll talk with anybody. No one reached out to me. Everyone knows, and Representative Sandick can attest to this, everybody knows that I'm a former federal prosecutor. If Rich Miller is here, he knows it. So it's no secret what my background is.
Well, Representative, I'm pretty available at most times. You didn't make any attempt to discuss me or bring me into the discussions, and nobody else did either, by the way.
As I said, when people reached out to me and said, are you willing to talk about this? I said yes. When people reached out to me and said, would you come testify? I said
So what
yes.
you're saying is the Democrat side of this commission reached out to you to find out if you would testify and perhaps to get a little idea of what your testimony might be?
No, they didn't get any idea what my testimony would be.
But just that you would testify.
That I would come here and testify. And had you reached out to me, I would have been happy to meet with you and provide you with the same comments that I
But
provided.
wait a minute, that's silly. How could I have reached out to you when I didn't know you were going to testify? That doesn't make any sense. There are, what, 2 million people in Chicago. I couldn't reach out to those 2 million people to find out if anybody was going to testify.
Again, the people who reached out to me know I was going to testify till they asked. Had you wanted to reach out to me and ask, or anybody else you wanted to come, you could have done it.
So what you're saying is that
available.
Democrat members of this commission reached out to you to ask you to testify. That's different than what you were saying initially. So I
Senator,
just want to make sure where we're at here.
I asked as well, because he's the only sitting member of the General Assembly who is a former federal prosecutor. So I asked for that response. Today, he is here, and he is telling us what it means.
And I
As
just
this
want to
is
make
an
sure
issue, the world has
politics
changed
must be
since the
put
subcommittee.
aside in the search of the truth.
Absolutely.
Thank you.
Further questions, Representative Sandak.
Good morning, Scott. Nice to see you.
How are you?
A couple things. You mentioned in your testimony that you thought it would be prudent for us as a commission to speak with the prosecutors, so we could work together. Yes?
Yes.
And you know, because you were probably at the prosecutor's office at the time, in the Blagojevich instance, that was a perfect example of different tribunals working in parallel ways in different instances, but working together and cooperatively.
At which point in times?
Well, there was an impeachment process along the same time as there was a prosecution over at your old building on Dearborn, right?
Right, but the reason that I'm asking that question is because during the grand jury phase of
They
that
stood down.
investigation, my understanding was that the General Assembly was not involved. When the charges were made public, and it became, we now have a sitting governor who's been arrested and later indicted, that the bodies were able to work it out. And my understanding is, and correct me if I'm wrong because I wasn't a member of the General Assembly, was that conversations outside of public forums like this were had between the U.S. Attorney's Office and members of the General Assembly, and they worked it out.
I think that's exactly right, Scott. In both instances, in that instance and in the Derek Smith instance, it was the federal government actually leading the charge. There was an indictment or an arrest that brought those federal charges, and then there were parallel but distinct state processes with respect to impeachment and removal. And there was conversation, so you're right, and I think would it surprise you to know that there have been conversations with the U.S. Attorney, Mr. Lewis?
It would be somewhat surprising to me, but I don't know if there's been a conversation since this letter was written.
What letter?
There's a letter that came from Mr. Lewis yesterday.
Yeah, that came at 4:30 yesterday. So that was actually to Senator Oberweis's point. At what time were you invited to testify today? Because that letter came at 4:30. So were you already going to be here because of the DOJ letter?
I was asked after the DOJ letter. I made a commitment to be here after I saw the U.S.
By whom were
Attorney's
you
letter.
asked, Scott?
By who was I asked? I already testified. It was Will Cousineau.
Cousineau, who is not, as I understand it, anywhere affiliated with the Legislative Audit Commission. Do you know if he has a position on staff with Mr. Holland's office?
I don't.
Do you see him here today, right here?
I do.
Yeah? Where is he?
Mr.
Where is
Cousineau,
he? Point him out, please.
he's standing back there in the corner.
Yeah, he works for the Speaker, right?
I believe so.
And you're a member of the Speaker's caucus, isn't that correct?
I'm a Democrat.
Okay, and you spoke to Democrats on commission prior to testifying today, correct?
Yes.
And you did not reach out to Senator Oberweis, myself, and we know each other, and other members of my caucus with respect to your testimony this morning, did you?
That's correct.
Okay.
And I
so you
also
read
didn't
your-
reach out to any Democrats
You didn't reach out to any Democrats?
No.
You just happened to speak with Democrats on this commission?
who reached out to me.
Got it. But you did say it was important to talk with the prosecutor. My side, my attorneys and the Senate attorneys did talk to Mr. Lewis.
Okay.
Would that alter your testimony at all if you knew we had a conversation?
I'd like to hear what it was.
So it may alter it may alter your testimony, but you want to know what it is.
It wouldn't alter my testimony unless it said that his letter was wrong.
Oh, so it doesn't matter what he said.
Well, no, it matters, but there was a letter at 4:30 where he said, I'm asking this body to not take further testimony. And I have the letter if we want to quote from it.
So do I.
And so that's what he said. If the conversation with him was, he said, I think it's a good idea for you to have this public hearing tomorrow, I would like to know. Absolutely.
Well, if he said that, you probably wouldn't be sitting here because the people you talk to would say your testimony today wouldn't be necessary, right?
I don't know. I can't predict what that would be.
Mr. Lewis also did say, however, in connection with the subpoenaed witnesses, not his request not to take testimony, he did say he had no problem with this commission collecting documentation from the subpoenaed witnesses and also seeking additional documentation. Isn't that right?
It is.
Okay. Do you have an opinion you want to share on that?
If I may.
No, you may not. I'm asking the question.
Well, when he is done, I would then
Fine.
respond.
Do I have an opinion on what? I'm sorry.
On Mr. Lewis's request, that statement that we are free to continue to look at documents, seek documents from subpoenaed witnesses, and continue our investigation or the review of this audit with respect to documents that help us in that review.
That's what he wrote.
I'm asking what your opinion is, sir, on that.
But I guess the
You're
question
here as
is-
an expert witness talking about what the U.S. Attorney does or doesn't do, and now
Right.
I'm asking you in that endeavor
Right.
what your opinion is on that portion of his letter.
But I guess I'm not understanding what the opinion is for.
Do you have any kind of opinion on his permission, clear permission to continue to look for documentation from subpoenaed witnesses or other parties?
My testimony has been that you should respect the request of the U.S. Attorney's Office,
So then you're in furtherance of, and you agree that that's okay for us to do?
provided that he continues to say that it's okay.
Yes. So that portion of the letter you also agree with, and you think that's okay?
Sure.
Thank you. I have no further questions, Mr. Martino. Thank you.
Okay.
What
For a little
what I would like to add-
clarification, if I could.
Go ahead.
On that. In the meeting with Mr. Kellner of the Justice Department, I made two requests. One is that the request for us to defer for 90 days be placed in writing. He said he would get back to us quickly. I also told him in that same meeting that jointly we had requested emails from the governor's office, which we were expecting. Do they have any recommendations or requests regarding those emails? And so letter is in answer to both of my requests made amongst all four caucuses with Representative Barrickman, and Faith Burton, who is the Special Attorney Assistant for the U.S. Department of Justice, Ken Kellner, U.S. Department of Justice, who was the lead counsel for the Government's Ethics Commission, and those members. And they responded very quickly, but I wanted answers to both of those so I knew when we could pass the information to the general public as well as to the members of the commission. So that's just as a little clarification where the 2 points of that came from.
Mr. Chairman.
Thank you, Mr. Drury.
If I may, there's been some questions about documents and whether or not, what my opinion is as to documents. Should this body decide to move forward with collecting documents and heed the U.S. request in all other respects as well, I would just point out that the normal course in an investigation for documents is not to drag witnesses out in public and have them turn over the documents in a big ceremonious way. They can just produce the documents, they can be reviewed, and then if there's follow-up, you can do that. Now, the commission will handle this however they want to do that, but again, I think that the commission should just be cautious of what they're doing because, again, grand jury proceedings are secret, and they're secret for a reason, and historically they've been secret. And if we want to debate whether that's the best way to find out the truth or not, we can do that, but that's the way that it's done. And so if this commission is going to move forward in any way with looking at this, they should know that it's not going to be done in secret, which gets back to what the U.S. Attorney was saying, is that it could impede the investigation. And I just think that everybody needs to be really cautious about this. No one is asking this investigation quelled. If there's wrongdoing, we should find it out, absolutely. That's why I wanted to I was thinking about writing about this before anyone ever talked to me. We should want to find out what happened. If there's criminal charges, we should find them out. I don't care what party the people are from. We should find them out and they should be brought to justice. The question is this body the best body to do that? And I emphatically say the answer to that question is no. And we need to take that seriously. And that's not a political comment for me. I've taken several votes on both sides of the aisle on issues, and if people want to debate that, that's fine. I am here wearing the hat of a former federal prosecutor who is concerned that we have gone astray, that we are beyond what a legislative audit commission probably should be doing. We have a request from the federal government to stand down, and for whatever reason, we have to debate it in public whether we should listen to the top criminal justice official in the Central District of Illinois. We should heed his request. And I think that it's, in my experience, unprecedented to ignore that. And I think it is a dangerous path to head down. But thank you again for allowing me to come here before you.
Mr. Crespo?
Thank you, Chairman. Scott, thanks for coming here today. And just for the record, I did support issuing the subpoenas several, I think it was last month. And back then, we even knew that the feds were looking into this. We also knew then, we know now that the state's attorney is looking into this. However, since then, there's a new development, obviously. We're getting a request from the federal government, and I've spoken to other former federal prosecutors to get some sense of, you know, how big is this thing. So let me ask you, does the Department of Justice, other than just asking us, do they have any other option, vehicle to enforce that, asking us or telling us not to do this? Is this the best they can do, or do they have other options?
You know, I've never get past this point of them making the request and people sitting down and coming to conclusions. There may be other options, but I don't want to guess and be wrong as to what they would be, whether they can go to court and try to stop this process. I think that would be very disrespectful of the U.S. Attorney's Office for this body to take an office that is resource challenged just like the state of Illinois and have them use their resources to stop a public body from trying to accomplish the common goal. And that's why I'm here, is we're all in search of the same goal, yet we're taking up a lot of resources, both state and federal now, to try to get to this goal. And I think from the public's perspective, they're just wondering what is going on and why can't this be worked out.
So based on your experience, usually when it gets to this point, that entity that's been asked to stop usually goes along with it.
Whether they stop or they have a meeting and they say, let's, sometimes task forces form, and I don't know what would happen in this case, but
okay.
it's worked out in some way. And the fact that wasn't happening here is what's concerned me.
Thank you, Scott. Thank you, Chairman.
Senator Barrickman.
Sure, thanks, Mr. Chairman. Sure.
Representative Rice.
Mr. Chairman, if I might, I would like to make a motion that Senator Barrickman be put in the chair's position.
We have a motion and a second. Discussion. From that will require 7 votes. Representative, the motion, this is a co-chaired committee. I am in the chair, and my ruling is that motion is out of order. You may appeal the ruling of the chair. That takes a 3/5.
Your declaration, Mr. Chairman, is that the motion is out of order, or
Yes.
on what is the basis for your finding?
Because that is the ruling of the chair. I had gone to the gentleman for questions of the witness, and so we're none that. So that motion is out of order.
You intend to honor that motion immediately upon adjournment of the witness?
You have the option to appeal the ruling of the chair. That's the ruling of the chair. Further questions to the witness? Representative Rita.
Scott, can you maybe explain a little more in detail how would this compromise the criminal investigation if we continue to go forward with not honoring the request of the U.S. Attorney?
There's several ways. Like I said, firstly, it's possible that it's already been impaired somewhat by the fact that the U.S. Attorney himself had to publicly state that there's a criminal investigation going on. So
we have already now put a possible compromise into the criminal investigation.
Potentially, because in the normal world, people wouldn't know that there was a criminal. The public wouldn't know. There wouldn't be all these cameras around. hearing about a federal criminal investigation. If there are witnesses that you're calling to testify that are also potential witnesses in the criminal investigation, those witnesses may be deterred from cooperating with the government. Those witnesses may in public say something under the lights of a camera to save themselves from embarrassment that may not actually be true, and then hurt their credibility and hurt the government's possibility of successfully prosecuting somebody. There's the possibility of working at cross purposes. The investigations could be at different points in the investigation. One could be trailing the other, catching up to the other, and it could impede the one that's behind from doing a maneuver or directing the investigation that a way that they want it to go, because it's already, some witness has already said something, or this body has done something that precludes that from happening. And so the short answer would be, it just will have, it creates the potential for a whole lot of people tripping over a whole lot of each other. And that is not the way that a serious criminal investigation should be conducted. And that's why I think that the request had to be made publicly like this, was to stop this from happening. And like I said, in the normal course, that letter would have been good enough. Now, I don't know if the letter was sent publicly to the press or the letter was leaked. That in and of itself, if it was sent privately to commission members, you know, that could be a way that it was compromised. You know, just because the U.S. Attorney writes a letter to this body asking it as a fellow well, not, they're different branches, but asking it to, to listen to its request, and then find that letter put out in the press 5 minutes later or 20 minutes later, that could hinder the investigation. And it's things like that where they're competing, they're trying to do things under the auspices of a grand jury, which should be secret. This body is trying to do everything publicly, and we're seeing how that plays out, that every move that is made is made public. And I understand why people may want this. We have to look at history in Illinois, and it has not been the General Assembly that has attacked public corruption. It just hasn't done it. And the body that has been the U.S. Attorney's Office. And the U.S. Attorney's Office is looking at a criminal investigation and saying that they think that we should stand down as the General Assembly. And if we don't, then it's kind of embarrassing to the state of Illinois, again, on a public corruption matter. And I just don't know why we want to be in that position. And that is not a partisan statement. I'm actually quite surprised that this hearing even went forward, to even have me testify. I kept saying that everyone was going to agree not to be here today. But I was wrong about that, and we're here. But I'm speaking again as a citizen, as someone who's worked on investigations like this, and saying that this approach is nowhere close to the best approach for a criminal investigation. And if people are concerned that something was wrong with the Neighborhood Recovery Initiative in a criminal way, then we should let the U.S. Attorney do its job. And if we think that the U.S. Attorney's Office can't do its job, then I ask someone on this commission to publicly state that, and state why you think the U.S. Attorney's Office is incapable of doing its job. Because if not, I think we should heed the request.
Further questions, Senator Mulrow?
Thank you, Scott, for coming here today. It's been very helpful. You know, I'm a former assistant state's attorney with Cook County, and when we brought our cases, the captions read, "People of the state of Illinois versus the defendant." I believe the caption in the federal cases are the U.S. Department. Is that correct?
The United States of America versus the defendant.
All right, and that's on behalf of all the people of the United States of America. It's not, singling out Democrats or Republicans or anybody who doesn't have a party affiliation. When a federal government, the U.S. prosecutor tells an individual, I'm not talking individual in this part of this commission, although I am concerned that us even participating in this process is interfering or obstructing with their investigation, which gives me great concern as well. But just take it down to a civilian. A civilian who is told to refrain from interviewing a witness who is part of an active criminal investigation. If that person disregards or defies the U.S. Attorney's Office because they think they're smarter than the U.S. Attorney's Office and wants to move ahead without them, what happens to the regular citizen of the United States of America.
So if a citizen interferes or attempts to interfere with another witness or someone called to testify, they could potentially be charged, I believe it's 18 U.S.C. 1512 with obstruction of justice, or under 18 U.S.C. 1503 as well.
Can I, as part of this authorization of the subpoenas, I've heard from members, not only at that meeting, but also in an interview I did on TV, that they'd gladly step aside if the U.S. Attorney's Office asked them to refrain on a FIP and now want to continue with it, notwithstanding their previous statements, because we're trying to investigate a crime and possibly hold someone that's responsible for breaking the law, rather than postpone this commission and take it up at a later time. I mean, we've already dissolved the agency. Why, can you give us a little reflection on, or why aren't we going to be held personally or criminally responsible for interfering with the U.S. Attorney's investigation if we start participating in this process? It bothers me a lot.
I don't want to make a statement and it be viewed as legal advice and be wrong. I think in that respect, there's some provisions in Section 1512 and 1503 that may provide guidance on that, but to the extent that anyone is concerned about that, I think that lawyers for the commission should discuss that. I don't want to be in the position of saying it is or it isn't obstruction. I don't want anything to be read into that, but if that's a concern, then the commission should absolutely consult with its attorneys and determine whether or not moving forward would be problematic.
All right, thank you.
Further questions? Senator Barrickman. No further questions. Thank you very much for joining with us. I appreciate
Thank you for all your time and your
comments.
questions.
At this time, we would go to witnesses. Since we do not have a schedule of order, I would ask the witnesses come forward or their counsel.
Thank you. I was starting to say Dr. Tony Irving is not here this morning because of her belief that it would be inappropriate for her to do so in light of the U.S. Department of Justice investigation, in particular, the now 2 requests that we've seen from the DOJ that this commission postpone the taking of testimony. I do want to be clear that Dr. Irving welcomes the opportunity to provide relevant testimony to this commission, but with respect to the Department of Justice and in particular regard to the risks that are raised in the 2 communications from the department, it is not her intent to testify at this time.
Sir, please continue.
Can I clarify, though, again, for the body, to understand that communication? Her intent is not to appear and testify, or her intent is to simply, in response to any questions asked by the commission, to simply plead the Fifth? What is her intention? Can you clarify that?
Yes, she has absolutely no intention of pleading the Fifth. I didn't say that, and I do not intend to say that. Her intent is to postpone her testimony and not to risk the obstruction and other issues that were addressed and raised by the 2 communications from the United States Department of Justice. And that is her position and will continue to be until this issue is resolved.
And again, to clarify, so her intent is not to honor the subpoena?
Her intent is not to provide testimony in deference to the request of the United States Department of Justice.
Is your client's intent to produce the documents that she has made this commission aware that she possesses, state documents that she has taken into her possession as a part of her departure from state government? We are aware through communication, possibly from you, that she is in possession of those documents. The subpoena that is at issue here requires her to turn over those documents now, and we have no communication from the Department of Justice at all that indicates that she should not comply, or that her compliance with that request would in any way jeopardize the federal government's criminal investigation of Governor Quinn's failed NRI program. Does your client intend to comply with the subpoena?
Absolutely, and I believe you did hear about that request, if not directly, of course, through me, from me in disclosing to counsel for the committee, or at least a member of the committee, as well as Ms. Strickland, that she possessed something in the order of 107,000 emails. I believe duplicative of the emails that you have received, my understanding, from, or at least a subset of that group that you've received from the governor's office.
The
I have
governor's
been-
office has provided us some roughly 2,000 emails from at least 6 witnesses covering a 2-year period. The governor's office has indicated that the emails that have not been turned over are privileged documents. They have not indicated to us in any way the nature of the privilege that they're asserting. But I think what I just heard from you is that your client possesses in her control well over 100,000 documents. This committee's in receipt of a subset of those, some 2,000, many of which, quite frankly, are not documents that involve your clients, their emails. They don't have your client's name on them. So it's fair to say this committee, this commission has less than 2,000 documents pertaining to your client. Your client holds well over 100,000 documents. Is your intention to turn those over today and comply with this subpoena request?
I have been in communication with counsel for members of this committee about the way to turn over
Who did you
documents.
communicate with?
Heather Weir.
Could Heather Weir be identified for us? Who is Heather Weir? Is Heather Weir's counsel to the Speaker?
She is the counsel to the Speaker of the House of Representatives and the Democratic Council.
Thank you. Is your intention to comply with the subpoena?
My intention is not to produce 107,000 emails today when I've not been through those emails to determine whether or not they are responsive or relevant or privileged. And I would note that it's not my privilege or my client's privilege. It would be the privilege of the governor's office or the state, presumably. My efforts have been to reach an accommodation which is, in my experience, typical of the act of producing documents, particularly of this magnitude, so that the commission can get what it needs and we all don't have to go through the time and the trouble and the expense of culling through them. The preferred way of doing that, in my view, would be for the state to review them, the governor's office, whoever is the appropriate person to do that, and then determine which they're going to assert privileges for. Again, it's not Dr. Irving's privilege, and then produce those. I was told, I was under the understanding that this issue could not be addressed until this morning, which is why I'm here without 107,000 emails.
We too, Counselor, wish to be accommodating. Unfortunately, we're left as a body of making decisions over the course of today and tomorrow about how to proceed. This body has issued subpoenas. Those subpoenas have been received by your client, presumably the others here. And we have to make a decision over the course of today and tomorrow about how we intend to enforce that subpoena. I think I don't want to speak for others, but I can tell you that we wish to be accommodating with you. However, it is more than alarming to know that the governor's office has turned over a subset of documents that total 2,000 from, I believe, 6 witnesses, and that you, on behalf of one of those witnesses, have withheld from this body well over 100,000 documents that we have asked for.
Well,
And so, I think the question that will come before us, and again, we'd like to be accommodating with you, is we are going to need to choose a path of whether to enforce the subpoena or to hear from you some reasonable proposal for how you intend to turn over those documents directly to this body. The governor's office, with all due respect to it, I think has raised concerns by the nature of the limited number of documents they've turned over to us already. So do you have a proposal for the committee to consider about how those documents will be forthcoming and when?
Yeah, I do. 2 quick observations up front. First of all, I quarrel with the concept that I have withheld anything. I am here at the first meeting since I received the subpoena, and I raised the issue of the possession of those emails to parties that I believed were the appropriate parties to raise the issue with. Second, I do not mean to suggest in any way that those 107,000 emails are relevant to this investigation or this inquiry or within the scope of the subpoena. My understanding My understanding is that Dr. Irving was provided with disks containing all of her emails for the entire period of her service when she left government service. That's what's contained on the disks. If the governor's office or anyone else wants to assert a privilege for those documents, then my suggestion is to do what I believe is appropriate and typical in these circumstances and allow the governor's office or anyone else who wants to assert a privilege to review them, assert the privilege, and then allow the production of all remaining documents.
For the record, also, the Counselor Vaught, when she was contacted by you, immediately contacted Counselor Johnson about it with the discussion of those requests. So both staffs have received that.
When are you going to go through the exercise of determining what's responsive so that you can, on behalf of your client, respond to a lawfully served subpoena?
Well, I have also had the opportunity to communicate with John Schaumburg, who I understand is the governor's, is the general counsel. My suggestion would be that at a break or when I'm allowed to step away from this table, that I reach out to the governor's office.
Excellent. I think that's a great idea, sir. Thank you.
Further questions, Senator Brady?
Thank you, Mr. Chairman. Mr. King, this body issued a subpoena, and I'm going to confess I'm not a lawyer, but this audit commission, not the Speaker's office, not counsel to Republicans, issued under its authority a subpoena. And that authority bears with it the weight of the statutes of the state of Illinois. We are all here duly elected people to represent the people of Illinois. Does a subpoena not require your client to appear?
The subpoena asks for my client's testimony and for her to provide testimony.
Does it ask or does it require under the statutes of the state of Illinois and the authority this body holds your client to appear?
The subpoena requires on its face, I do have the subpoena in front of me. The subpoena commands her to appear, I believe, is the...
So that's not asking, that's demanding, and it carries with it the full weight of the statutes of the state of Illinois. And as duly elected representatives, I find your advice to your client not to appear be in contempt in a broad range of words. I want to know what authority you think you have to tell your client to avoid a statutory requirement.
Well, first of all, I'm not going to get into any advice I've given to my client. Second of all...
Wait a second, you already have gotten into advice. You've already started in your opening remarks by saying you advise your client not to appear due to the nature of a lawsuit, but you have not advised your client not to take the Fifth Amendment.
I believe what I said was my client would not be asserting her Fifth Amendment, and that is absolutely the case.
You didn't advise your client not to assert the Fifth Amendment?
I'm not talking about what advice I gave, most respectfully. With respect to your question about...
Well, then who gave your client the advice not to appear subject to law of the subpoena issued?
Sir, your question with respect to the authority, and I'll actually direct you to what I understand to be the authority, and I understand this because this was provided to me along with the subpoena, is contained in Section 4 of the Legislative Audit Commission Act, and that provides for the following. Should any person fail to obey the summons, and I'm going to skip through to the pertinent part, the Commission may apply to the Circuit Court, and such court, if it finds that the Commission has not exceeded its authority, may, by order duly entered, require the attendance of witnesses in the production of relevant books and papers. Upon refusal or neglect to obey the order of the court may compel obedience of such order by proceedings for contempt. My understanding is that that process has not happened, and the suggestion that Dr. Irving is in contempt is, in my view, incorrect.
So you did advise your client that she didn't need to appear?
I am not talking about advice. I am not going to respond to...
Do you represent your client?
Do I represent my client? Yes.
Did you advise your client?
I am not talking about advice that I gave my client. You may or may not be aware that would be privileged information, and I would not be permitted
I didn't ask for the
provide.
privileged information. I just wondered if you advised your client.
I've obviously spoken to my client. I will not provide the advice I gave, nor would it be reasonable to ask
So
any...
you believe that a subpoena issued under the laws of the state of Illinois by this body is a preliminary step and not a true requirement?
I'm merely reciting, sir, the statutory provision which was provided to me along with the subpoena. And as I read the provisions, again, first, should any person fail to obey the summons? Second, the commission may apply to the circuit court for an order. Third, upon refusal and neglect of the order, the court may compel obedience of such order by proceedings for contempt.
We understand that, but I just want to tell you that I find the fact that your client is not here, as well as the rest of you, for whatever reason you may give, to really be an affront to the people of Illinois in the process. I also want to point out that this is not a criminal investigation, as someone suggested earlier. This is a legislative body that is authorized and obligated to review audits of the state of Illinois so that we can determine what can be best done to move the state forward in a proper way. Your client and others were found to be less than exemplary in their efforts to do the work of the people of Illinois, and for them not to come in accordance with the subpoena to help us improve, I find alarming, sir.
Well,
Thank you.
all I can do is repeat what I've said, that Dr. Irving welcomes the opportunity to come here, to testify, to provide any information that this commission requires of her, but not under circumstances where the Department of Justice has 2 times said that for her to do so would risk serious damage and harm to their ongoing grand jury investigations. That is not intended by her as an affront to this commission, and she will respond when it is appropriate given the...
Well, is your excuse for not providing over $100,000 emails the same? Because the U.S. Attorney's Office never suggested we shouldn't collect data. You were subpoenaed to provide those here and at this date, not to discuss providing them at this date, but to provide them here at this date. Are you using the same excuse that we're going to have to go get a court order?
Nope, absolutely not.
Why did you not meet the obligations to the subpoena to provide the documents?
Because there is a request, there is, my understanding, there is a privilege issue with respect to documents. I attempted, as is the normal process in my experience, to...
Does she have the documents in her possession?
I have 107,000 emails in my possession.
Why are those privileged? They're hers. They were subpoenaed. Why are they not here today?
Again, if the governor's office wishes to assert a privilege, Dr. Irving is not asserting
The
a privilege.
governor's office, have they asked you not to provide the documents?
No.
Then why wouldn't you provide them? They understand what's going on.
I'm sorry?
They understand what's going on. If they ask you not to, if they provoke their executive privilege and asked you not to provide the documents, I could understand yours. But no one's asked you not to comply with a subpoena to provide the documents. Not the U.S. Attorney, not the governor's office. You simply said, we're not bringing them.
I said we are bringing relevant documents when I'm told...
Wait, did we ask you to provide relevant documents, or was the subpoena to provide the documents?
The subpoena...
Actually, yes. The request was for NRI-related documents.
Well, okay.
And the 107,000 are not.
Wait, he just said he's got 107,000 NRI-related documents.
No, that's not what I said at all. What I said is I have 107,000 documents. It is my understanding, and I have not been through anywhere near all of those documents. It is my understanding that those are the entirety of the emails that were on her system at the moment in time when she left the employment of the state, and that they are all of her emails during her period of time when she was employed.
Why didn't you advise her to comb through those and provide them at the required time?
Again, as what is, in my view, a customary way to proceed in this regard, I reached out to people that I believe to be lawyers who are in a position to decide the best way to produce these documents.
I just spoke with our counsel, and she says she never gave you authority not to provide them.
I believe that is an incorrect statement.
I don't know.
No one gave authority. Right. Were you told to not produce documents?
No, absolutely not.
Okay. For clarification.
So why did you not produce documents? Why are you not producing documents?
I think I've said this several times already, but I'm willing and able to say it again, because there are documents that are not relevant. There are documents for which I believe.
Well, provide the relevant documents. Why have you not provided the relevant documents according to the subpoena?
Because the process which I described a moment ago.
They both said they didn't tell you that.
Yeah, if you would allow me to answer the question, no one told me how to proceed. I affirmatively reached out in an effort to resolve this ahead of time. I'm not standing, as you noted, on the provision here in Section 4 and requiring this commission to obtain an order. I'm perfectly willing to provide documents.
When was your client served with notice to provide the documents?
Sir, I believe you made a request of the council related to both councils, all councils of the 4 caucuses, that said it was your belief that the emails were duplicative of what the governor was to provide. Is that the statement that you made to the councils?
Yes, and it's my understanding that has been communicated directly to Heather Weir or Wire, if I'm pronouncing the name correctly.
Do you think that eliminates your obligation under the subpoena to provide them? Are we going to get these documents or not?
You are going to get the documents, and the process that I worked out seems to me the appropriate way to proceed, which is that I reach out to the governor's office. If the governor's office wishes to assert a privilege for them.
We don't think the governor's office should be involved. They could do so. If they're trying to protect from being disclosed, they could proactively take that venue. Why would you approach them? Have you talked to someone from the governor's office who's asked you to do this?
I have talked to someone from the governor's office and about that issue, and as well as the issue of the duplicativeness of these emails. In fact,
who did you talk to in the governor's office?
John Schomburg.
And what did John Schomburg tell you?
I believe if my recollection is correct.
And for the record, what's his title?
He is the general counsel. If my recollection is correct, what I spoke about with Mr. Schomburg was a process for eliminating duplicative emails from the collection that we have. It was my intention to raise that with the commission this morning, and that's what I'm doing. I don't believe that it is in anybody's interest that we go to the time, trouble, and expense of producing emails that you have already.
That's not in your purview, sir. This body issued a subpoena. I'm not a lawyer, but this body issued a subpoena for documents. The U.S. attorney never told you not to do that, so your excuse for your client not showing up can't be used in the case of the documents. Never told you, will you check with the governor's office before you do it? You were compelled by statute to provide these documents here and today. Why have you not done so?
Again, sir, for the 4th time, because of the duplicative nature of the emails, because there are, in my understanding...
Is that within your purview to determine whether they're duplicative or not? One of the reasons we might want them is because someone else may not have provided them. It's up to us to determine whether they're duplicative, aren't we? Isn't it?
It is within my purview to determine what is a responsive document. But
you didn't bring one.
I didn't bring any because I had discussions beforehand about the best way to produce them. I can't say that any differently.
Yeah. Sir, I find your actions and your advice to your client in contempt because the subpoena is pretty clear. It says all relevant documents should be delivered by this date. You and your client have had over 1 month. It doesn't say for you to determine whether they're duplicative. Provide them. And I would recommend that you do so immediately.
Further questions? Senator Mulrow.
John, I just want to make sure I understand that there's 100,000 emails. Some may be relevant, some may not be, and you haven't gotten through them all. Is that correct?
That's correct.
And there's some duplicity going on, some other things that may bar the privileges or whatever. So what I'm hearing you today is say, hey, you didn't present your client because of the letter from the U.S. government, and there's these 100,000 emails that you haven't had a chance to get through. And I just want to point to you that Section 4 of our statute that provides, a person who fails to appear. So it says, should any person fail to obey the summons or refuse to surrender or afford access, it says without reasonable cause, the commission can apply for some court intervention to force this from happening. So to me, I mean, sounds like what you're telling me is that you have reasonable cause to ask for more time, consistent actually with the U.S. government telling us to refrain from asking any questions of your client. So is that basically what you're saying?
It is, although again, I'm not suggesting that we will not produce the emails because of the grand jury investigation, but absolutely that my intent was to come here and work out a process for producing some portion of 107,000 emails, and again, under the assumption that the vast majority of those emails are not within the scope of this inquiry, and some may be privileged.
Okay, and I, like you, I'm not alarmed that your client's not here because we have the federal government asking us to refrain from talking to her. Otherwise, she and us would be interfering with an active criminal investigation where we're going to find out whether there was any wrongdoing, criminal wrongdoing, that we want to hold somebody responsible or accountable for if that in fact exists. So I guess I'm alarmed that we're here, continuing with a process that we can defer consistent with what the U.S. Attorney's Office has asked us to do for 90 days while we are jeopardizing or compromising a criminal investigation. So I don't know whether you wish to comment on any of that or not.
I don't, thank you.
Nope. Question from Senator Berrickman.
But just to follow up, so I understand again, because we're going to need to make some decisions here today. You have asserted in a line of questioning with Senator Brady that you believe the documents held by your client are duplicative of those that the governor has turned over to this body. I draw from that statement two things. One, you've reviewed your client's documents. Two, you've reviewed the documents that the governor has submitted to this body. Is that true?
No, neither of those.
How do you know that they're duplicative?
My understanding is that the governor's office provided, and I may even have received some of these emails from Ms. Strickland, but that the governor's office provided emails requested by this commission, which were, for want of a better term, relevant and within the scope of your inquiry. By definition, if I have 107,000 emails, which is every email that was on the system at the same time as those were produced involving Dr. Irving, then I would be under the understanding that you would have those emails already.
Let me understand. Has Ms. Strickland provided to you certain emails that are in possession of the Audit Commission? I think you just suggested that.
I believe so. I have a disk I received from Ms. Strickland.
Ms. Strickland, can you make the Commission aware of what emails you have provided to Mr. King? I think, let's have you speak into the mic.
I'd have to, Senator Berrickman, I would have to go and look at my email record, but I think those are the ones that the Auditor General provided us, the Barb Shaw emails.
Let's get some clarification, if we can, on that, Ms. Strickland. Mr. King, you've also asserted this suggestion that your client may raise a privilege that the governor's office has raised. The governor's office, to be clear, raised no privilege with any specificity, which is, for those attorneys in the room, I think is a questionable act. But for the sake of your testimony to us today, what privilege would your client claim on documents that she has taken into her possession, documents that I believe by state law are documents of the state of Illinois? Ms. Irving is no longer an employee of the state of Illinois, and she has these documents in her possession. Therefore, the question is, what privilege would you intend to assert on any documents of those 107,000 that you do not turn over to this body?
I believe I've said several times now that Dr. Irving is not asserting any privilege.
You have said that she, and in fact, I think the communication that came to this body suggested that she would assert the same privilege that the governor's office has raised. Do you believe that your client has has certain rights to raise privilege upon the documents that we've requested?
What I think I've said this 3 times now, what I did in this case in advance of this proceeding was reach out to the governor's office and to lawyers who I believe to be associated with this commission and who would be appropriate to work out a manner and method of production in advance, again, in order to determine whether the governor's office or anyone else was going to assert a privilege. My hope was that any privilege issues asserted by anybody not including Dr. Irving would be worked out in advance of this date. That did not happen. In fact, my understanding from the communication I received back from Ms. Weir was that this commission could not take up that issue until today. That being the case, there is no process, apparently, to do what is normal and typical in my experience, which is to work this issue out in advance of the hearing. That's why I'm here describing what we have. Again, we raised the issue. Dr. Irving and I raised the issue of her possession of these emails in advance of the hearing in order to have this issue addressed beforehand. Apparently, it can't be worked out beforehand. As I mentioned, I would say a moment ago, but it isn't a moment ago, at a break, I think an appropriate way to proceed is for me to reach out to Mr. Schaumburg and see if the governor's office is asserting any privilege.
Okay. Final 2 here, I think. So the reason that you did not comply with the subpoena requiring your client to produce documents is because of a communication that has been, or an interpretation of a communication that came from the Speaker's Counsel to you that compliance with that request was not necessary.
I quarrel with the term "was not necessary." It is my understanding that that by my coming here today, which is the first opportunity to raise the issue, that would be an appropriate way to do just that.
And your understanding, though, comes from your interpretation of communications you've had with the Speaker's Counsel on this issue. You certainly have had none of those conversations with me.
I have not had any communications with you. That's correct.
Okay. And then lastly, I think, and I want to respond to Senator Mulro's comments, that the Department of Justice has made certain requests to this body. Certainly that is true. But I believe this line of questioning that we have had, this dialogue with Mr. King, for all the members need to understand that line of questioning clearly falls within the scope of what the U.S. Attorney's Office has said that we should proceed with. So with all due respect to those who simply say we should shut the door on this matter and reconvene in 90 days, I want to be clear that the U.S. Attorney's Office has not requested that of this body. And so, Mr. King, and again, I can only speak for myself, but I would like to take you up on your request that you're going to convene with your client and that you will reappear before us here shortly and let us know how you intend, or your client intends to proceed.
Yes.
I have no further questions.
And further, we do have one from Senator Brady. Final question. I wanted to also note the subpoena, I believe, was received by you on the 27th. For mine, and I'll ask each of those.
I believe that's right.
Okay, so you've had 18 days, basically. So we'll continue on from there, but for my record, I'll be asking each of the councils that as well. Senator Brady.
Mr. King, if you get the answers that you're looking for today, since we're convening tomorrow, is there any reason you can't provide us with those documents tomorrow?
Short of mechanical difficulties with producing 107,000 emails, no.
I thought they were on a disk.
They're on several disks, right. I'll have to copy disks and produce them.
Think you could get that done in the next 24 to 30 hours?
I'm not a technical person, but I don't see why it can't happen.
Good. Thank you.
Mr. Tice.
Thank you, Mr. Chairman. I appear on behalf of Barbara Shaw, and I have a brief statement I'd like to read on her behalf.
Please do.
This commission's hearing concerning the audit of the Neighborhood Recovery Initiative is an appropriate exercise of its statutory function. Ms. Shaw's former position as the long-term director of the Illinois Violence Prevention Authority places her in a position to provide insight into the program, which began nearly 4 years ago as a serious effort to deal with a critical problem of violence in many neighborhoods. As you know, Ms. Shaw was the first and only director of the IVPA from its inception in 1997 until her retirement in 2012. Barbara Shaw has over 30 years' experience in violence prevention, and her experience might be a valuable resource for this hearing process. Ms. Shaw has been made aware through numerous sources that in addition to this commission's hearing, other bodies, including federal and state grand juries and law enforcement authorities in Cook County and the Central District of Illinois, are investigating some of the same areas of concern expressed in the Auditor General's audit of NRI. The existence of these inquiries, as has been pointed out this morning, is not a matter of speculation. Last week, a request was communicated to this body by the United States Department of Justice asking to postpone the testimony of several witnesses, including Ms. Shaw, for a reasonable period of time until these investigations were concluded or at least had moved significantly forward. The department stated unequivocally its concern that the public testimony before this commission, and this is a quote from their letter, would pose substantial risk to its investigation. A similar request was made yesterday by the United States Attorney for the Central District. Therefore, although this commission or members of this commission have expressed disagreement with, or at least skepticism of, the Justice Department's expressed concerns that parallel inquiries might pose substantial risks to the United States Attorney's investigation, it is Ms. Shaw's decision at this time that it would be inappropriate not to respect the intent of the Justice Department's request and the concerns raised therein, and therefore, until these concerns are resolved, it is her decision not to testify before this commission.
Thank you. Questions, Representative Sandak?
Good morning, Mr. Tice. Is it your client's intention to produce documents responsive to the subpoena served upon her?
I've been thinking about that in response to...
There's plenty of time, right?
Well, you were talking to Mr. King. I think you will find, and I've had a conversation with her, she, unlike what happened with some other people, she's a private citizen. She left Illinois Violence Prevention Authority in 2012. She retired. She did not take with her her files. Her files were all turned over to the Illinois Criminal Justice Information Authority, all of the files relating to the program, which is the subject of this audit. I would be surprised if there are any, but certainly very few, documents that you don't already have.
Well, that's not quite what I asked.
Right.
I mean, that may be the case, but that's
Right.
ultimately what discovery and subpoenas and document productions are all about.
Right.
And sometimes duplications occur, but that actually proves up that people have the same documents. So my question is, has she not looked or advised you that she has responsive documents?
Without going into specific conversations, of course she she's been aware of this, not only this commission's investigation, but the audit itself, and she is aware of what's in her possession. And I do not believe at this time, and we can revisit this issue, and I will contact your staff immediately if I learn that there's anything that she has that come under the definition of the what's responded in the subpoena. But I don't think there is anything.
Well, with all due respect, a formal request has been made, and as Senator Brady has made perfectly clear and quite accurately, it's a direction. What is typically the case is there is a formal reply that there are no responsive documents. We've checked, and here's our letter, or something from an attorney or a respondent saying, I have nothing responsive, or here are the 3 pieces of paper I have. So I'm hopeful that you will give the process that's been permitted to continue through the U.S. Attorney, which is the production of documents that is unequivocally clear, and that you will go to your client and then you will formally respond to the request to the subpoena for documents that were served upon her that she's had in her possession for some period of time now. So I'm hopeful you'll do that.
Right. If they exist, I certainly will.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.